One break in chain of custody, and your entire case is gone. Years of work, hundreds of artifacts, hash-verified images, all of it inadmissible. Because somewhere in the timeline, a signature is missing, a form is incomplete, a box of evidence sat on a desk for 90 minutes, unlogged. Welcome to the law, where digital forensics meets the courtroom, and where the difference between a conviction and a dismissal is paperwork. Start with the headline law in the United States, the Computer Fraud and Abuse Act, CFAA. Title 18, Section 1030. This is the primary U.S. law governing unauthorized access to computers. It criminalizes unauthorized access, exceeding authorized access, computer fraud, damage to protected computers, and trafficking in passwords. And here is the key phrase: protected computer, defined as any computer used in interstate commerce or communication, which means every internet-connected system in America. Enforcement: FBI, Secret Service, DOJ. If the exam mentions unauthorized access to a U.S. system, think CFAA first. Next, the Electronic Communications Privacy Act, ECPA. 3 titles you need to know. Title 1, the Wiretap Act, prohibits real-time interception of electronic communications. Title 2, the Stored Communications Act, SCA, governs access to stored emails and cloud storage, requires legal process. Title 3, the Pen Register Act, governs collection of call detail records and metadata. Then came 9/11, and the USA PATRIOT Act of 2001. Section 215 allowed bulk collection of business records, heavily modified later by USA Freedom. Section 216 extended pen register to internet communications. And national security letters, administrative subpoenas with no judicial oversight, lowered the barrier for sharing intel between agencies and law enforcement. On the exam, stored emails need a warrant, real-time interception needs a wiretap order, different legal processes for different data types. Know the difference. Forensics is global, so is the law. Start with the United Kingdom. The Computer Misuse Act of 1990. 3 offenses: unauthorized access with intent, unauthorized modification. Then the Council of Europe, the Budapest Convention of 2001, the first international cybercrime treaty, establishes common definitions across signatory nations, enables mutual legal assistance treaty requests, MLAT, for cross-border investigations. Then the European Union, GDPR, the General Data Protection Regulation, governs processing of personal data of EU residents. Forensic implication: investigators need a lawful basis to access EU citizen data. Cross-border data transfers need safeguards. Penalties: up to €20 million or 4% of global annual turnover, whichever is higher. Other jurisdictions to know: Canada's PIPEDA, Australia's Cybercrime Act, Singapore's Computer Misuse Act, India's IT Act of 2000. Cross-border evidence: always check the treaty before you collect. 5 qualities make evidence admissible. Memorize all 5. Exam test them in any order. Authentic: the evidence is what it claims to be. Proved by hash verification and chain of custody. Reliable: the evidence is trustworthy. Proved by validated tools and documented methodology. Complete: the full picture. No cherry picking. You disclose exculpatory evidence, even when it hurts your case. Believable: the jury can understand it. Clear expert testimony, visual aids, plain English. Admissible: it meets legal standards, proper collection, no Fourth Amendment violations. Authentic, reliable, complete, believable, admissible. Miss 1, and a defense attorney has a path to get your evidence thrown out. Federal Rules of Evidence, FRE, 5 rules that govern what makes it into a federal courtroom. Rule 401, relevance: evidence must make a fact more or less probable. Rule 702, expert testimony, must be based on sufficient facts and reliable methodology. Rule 803, the hearsay exception for business records. Computer-generated logs are not hearsay. They have no human declarant. Rule 901, authentication. You must demonstrate evidence is what it purports to be. Rules 1000 through 1004, the best evidence rule. Originals preferred, but here is the win for digital forensics. Rule 1003 says a forensic bit stream copy with matching hash values is treated as equivalent to the original. This is why hash verification is the backbone of digital evidence. Fourth Amendment to the U.S. Constitution protects against unreasonable searches and seizures, requires probable cause and a warrant for government searches. But there are exceptions you must know. Consent. The user or authorized person agrees to the search. Plain view doctrine. Evidence visible during lawful access can be seized. Exigent circumstances. Imminent destruction of evidence justifies warrantless search. Border search exception. No warrant at international borders. Controversial. Extends to digital devices. Private search doctrine. Employers can search company-owned equipment without Fourth Amendment issues. Search and seizure documents you will encounter, search warrant, subpoena, court order, consent form. Each has different legal weight. Each requires different authority to issue. Get the document wrong, and you contaminate the evidence at acquisition. Now, the headline, Chain of Custody. Chain of custody is the documented chronological record of who had possession of evidence, when, and what they did with it. It proves the evidence was not altered, not tampered with, not contaminated, from the moment of collection through every transfer to presentation in court. What goes in the documentation? Description of the evidence, make, model, serial number, condition, date and time of collection, location where it was found, signature of the collector, every transfer, who to whom, when, why, storage conditions, access controls, and the hash values, MD5 and SHA 256 at collection, and every examination. Best practices, tamper evident bags, two-person integrity for high-value evidence, locked evidence rooms, never work on the original, only on forensic copies, break the chain, and the consequences total. Evidence ruled inadmissible, case dismissed, defendant acquitted, all the work for nothing. 2 more laws to lock in before we close. HIPAA protects health information, breach notification, 60 days. GDPR protects EU personal data, breach notification, 72 hours, different timelines, both tested, and the closing punchline for this objective. Chain of custody is not paperwork. Chain of custody is the difference between justice served and a guilty person walking free. Treat every form like the case depends on it, because it does. Next up, Objective 2.1, Investigation Phases and Methodology, the 3-phase model that organizes every CHFI investigation, from authorization through court testimony.